This week on Lewis on the Law, I have yet another great show for you. I have attorney Charis Dorsey on with me, and we're going to talk 18 common legal pitfalls for business owners.
Welcome to Lewis on the Law.
You are listening to Lewis on the Law, and this show is all about empowering you, the listener. And in that spirit of empowering, this show is going to be geared towards you, the small business owner, or, just the startup business owner, whatever you want to call it. I have attorney Charis Dorsey on with me. Hi, Charis. How are you doing?
I'm great. How are you?
Pretty good. And you're the principal at the Dorsey Law Firm. Is that correct?
That is correct.
Okay. Tell me a little bit about your legal practice.
Sure. So my focus is primarily on startups. I help aspiring, existing, and those seeking to exit out of their business. I help all of them in just the common day-to-day needs of their business, from formation to general contracts and all the things in between, even to exiting.
Okay, so you're basically a personal consultant for business owners then?
More or less, yes.
Okay, I got it. Okay, so this topic intrigues me. We've had a lot of shows geared towards startups and small business, and I know when we talked about the show idea, this touches on some of the areas we've gone through, but it's very cross-disciplinary. It goes across several disciplines. And so, okay, I got to ask, I'm intrigued. Why? And when you told me this, you said 18 common legal pitfalls for business owners. Why 18 common legal pitfalls?
Well, these are some of the most frequent issues that I see come up with business owners all the time, day in and day out. And traditionally, you like to limit it to 5 or 6 or a number, but it literally is 18. Just issues that are if knowledge was just readily available, could be avoided. And I just compiled them over my practice, and that's what I came up with. 18.
You came up with 18. It's like a magic number,
Yes,
right?
Yes.
It's not like 3 is a magic number. It's 18 is the magic number. So you do seminars on this. Is that correct? You'd like to do quarterly seminars on this type of topic?
So I host quarterly seminars, which kind of tie into my overall campaign, which is 100 Businesses Legally Sound. And so my goal for 2019 is to help at least 100 businesses to become legally compliant, from the structuring of their business to how they handle partnerships, and even with their intellectual property, making sure that their assets are protected. So I break them down into quarters, kind of touching on, or grouping rather, some of these common pitfalls into different segments, and then I host quarterly sessions to kind of keep them on par for the remainder of the year.
Okay, so you're keeping business owners in line. I got it. I love that. So where do we start out? What is the first? What is the first of these 18 common legal pitfalls? What's the first?
So I would just have to say that it starts with the formation of the business. I see this often enough. People start their business, or they do one aspect of it and think that they're fully compliant, and that can go from choosing the right entity, or taking some of the steps from the perspective of selecting the EIN or obtaining the EIN number and thinking that that's it, or registering with the Secretary of State and stopping there, or obtaining a business license but not actually registering with the Secretary of State. So I say the first part, or the most common, is actually selecting they either select the wrong business entity for their long-term needs, or they're not selecting one at all, or they're not formalizing their business properly. So I know there's like a lot of ors and buts in between, but I think that it all goes together in one category, honestly.
And that's the formation of the business entity. So what type of considerations are there for what type of business entity to form?
So the first thing is I would say the first thing to consider is your liability. Are you prepared to take on the financial risk that comes with running your business in the event that something were to go wrong? And so depending on what you're doing, how long you want to, conduct this business idea or venture, would determine what steps you actually need to take in terms of formalizing. Sometimes it may just be sufficient to actually move forward from the perspective of being a sole proprietor. Maybe it's a one-off deal. Maybe obtaining liability insurance is enough to cover you in that situation, and then you're done. But for others who are seeking to pursue much more long-term ventures, then maybe you want to look into possibly creating a LLC and filing your articles of organization, or if you're okay with some of the formalities that are associated with being a corporation, then maybe a corporation is the better route to go. So I would say that would be the first thing. And then the second thing is, how do you want to be treated for tax purposes? The general default for your LLCs and your sole proprietors is to be treated as a sole proprietor. Unless you're a partnership, then you're treated as a general partner. But there are a lot of implications with the tax component. So seeing if how many risks or financial obligations you'll have, and seeing how you would like to pass those risks on, or those losses on, rather, over the course of the year also determines or dictates, rather, which entity is the best entity for you from a tax perspective.
Wait a minute. So let me ask a question here. What are the tax implications? What are they? I mean, for sole proprietorships, how are they different for sole proprietorships or general partnerships? What's the difference?
So generally speaking, for a sole proprietorship,
or a corporation for that instance.
Absolutely. So for a general partnership, a sole proprietorship, where you haven't taken any formal steps to actually incorporate or organize, rather, then the entity itself won't be taxed. You'll be taxed as the individual.
Okay.
And so everything we call those pass-through entities, more or less. And so the tax obligations or tax liabilities just pass on to you on your general tax reporting, annual tax reports. And the same thing goes unless you tell the IRS otherwise. I always like to tell people, tell the IRS how you want to be treated. But
wait a minute, how do you do that?
Sure.
You just kind of call them up and say, "Hey, I want to be treated like a king."
I wish. But generally speaking, there are forms that are in place that you use to actually make a tax election. So depending on if you are going to be opting to be treated as an S Corp, then you would submit a separate form than you would if you want to be treated as a C Corp. And then so basically,
wait a minute, S Corp and C Corp? Yep. What you're getting really fancy on me here. Yeah. So what is an S Corp and what is a C Corp?
Sure. So I'd like to consider a S Corp like your hybrid from it's kind of, you get a little bit of the benefits of a corporation, and then you also get some of the benefits of kind of like a sole proprietorship from a tax perspective. So, and when I say that, I mean from the sole proprietor benefit, it gets to pass on through you. And so if you didn't have like a super profitable year, then sometimes it may be of interest to you to maybe even do that election or to take some of those benefits.
Sounds like my year's not super profitable.
Oh, stop it. But it allows you to pay the taxes on yourself as they pass on. So if you and your partner shared an entity, a joint venture, then you would share the profits. But with the S Corp, it allows you to write off some of the losses, whereas you would not necessarily be able to as a general partner or sole proprietor. And so that's why I say you get some of the benefit, because generally speaking with a C Corp, you're able to write off a lot more of those losses. As well, you're able to separate yourself personally from the business from a tax perspective. And so generally speaking, when I say that, the C Corp, the actual business entity is taxed, and then you are taxed as an individual from the dividends and the income that you receive as a result of that company separately.
Okay, so C Corps are better for larger organizations. Is that true? Or
I wouldn't necessarily qualify it based on the size, but more so based on long-term goals.
Okay.
So for a C Corp, you generally see a lot of businesses opt in for that because of the stock options, preferred stock you're able to issue. Whereas with an S Corp, you're kind of limited to 100 shareholders or stock owners. And as well.
So an S Corp is limited to 100 shareholders or stockholders. That's the most that you can have. It's like 100, no more. Okay, got it.
And they have to be U.S. citizens.
Okay.
Whereas with the C Corp, it's kind of like the Wild Wild West. You can have, a lot of more.
You can just get money from anybody, huh?
Well, I would say with a caveat that, when you're talking about actually receiving money, then you're getting into a conversation about private placements, and you also want to make sure that you're kind of in line with what the SEC says about that. the Securities Exchange Commission as well. Georgia has its own limitations as to how much you can receive. I generally tell people from just the first mind perspective, $10,000 is your number that you want to, start asking questions about where this money is coming from, and if it falls through one of the exemptions, or if it actually will need to be registered with the SEC.
But if it's $9,999, you don't have to ask. Okay, that's a good tip to know. Okay, we're at the end of this segment. We're about to get into 2 through 18. I think we just went through 1, but we're going to get into it. Charis, why don't you give them some contact information for you?
Sure, I can be reached on my favorite place to tell people to go is my website, which is thedorseyfirm.com. And on there's a contact us page where you can submit and fill out the form and schedule a free consultation.
Nice. You're listening to Lewis on the Law. My name is James Lewis. This show is all about empowering you, the listener. Remember, the information you hear on this show is only designed to be legal information. It is not designed to be legal advice. If you have a serious legal issue, you need to contract with an attorney. Don't use what you hear on this show, say, oh, I listened to Charis and now I'm ready to go with my business formation. Now, if you have a serious legal issue, if you need to form a C Corp, you need to go ahead and contract with an attorney. You can contact Charis Dorsey. If you have any other issue, you can contact me, James Lewis, at jameslewislegal.com, or you can give me a call at 404-610-0075. You are listening to Lewis on the Law. My name is James Lewis, and I have yet another fun, interesting, and exciting topic for you guys today. Charis, who knew the law could be so much fun?
I know. It's amazing.
I sure didn't realize it was going to be this much fun in law school. And when you see me in the middle of a heavy-duty litigation, remind me that this is fun.
Okay, I'll try to do that.
Because sometimes I forget, and I'm just like, oh, God, why did I do this? Why am I not just flipping burgers? It might just be easier. Okay, so that was a great segment. Segment number 1. We got through a lot. But that was just number 1. What is the second? Okay, because this number 18, I love it. It just intrigues me. What is number 2? What's the second common legal pitfall for small business owners or business owners?
Yeah. So number 2 would actually be separating yourself from the business. I see this often enough. You start with the business, or maybe you started for a year and then finally decided now is the time to take my business seriously. And when you do so, you leave yourself open for potential risks. I always say this, worst case scenario, if you're sued, would you be okay with your and if you're sued and you're doing this as a hobby or just as a side hustle or job, would you be okay with the money that you earn from your 9 to 5 being up for grabs in a judgment?
Ouch. Most people would say no.
Absolutely not. And so I always start from that question and then say, okay, if you're not, then why are you leaving yourself open for risk? So the things that I commonly see are taking the money that you receive from a business transaction and depositing it into your personal business account. We call that, in our world, commingling of funds, which is very, very much so problematic.
Commingling of funds? Is that not okay?
That is absolutely not okay.
Okay, got it. To clarify, just in case I decide to do that at some point in time.
That is a no-no, and I will actually pop you on your head. Yeah,
for attorneys, we have serious repercussions for doing that.
Absolutely.
Like losing your license.
Completely. So, and that's what we don't want to do. So, for you, for the common business owner, is starting up front with formalizing properly and, actually getting a bank account that is separate and apart from your own personal bank account that you use. And if you want to pay yourself from it, actually doing a 2-step process. If you're not necessarily ready for from the standpoint of putting yourself on payroll, maybe the funds aren't consistent enough for you to place yourself on payroll. At least writing yourself a check. And then doing the transfer that way versus just taking the check, depositing it into your bank account, and then spending the check directly out of your personal business account. So that's one way that I often see
it's a very common and easy to do mistake.
Absolutely. And then also, I asked that same question: would you be okay with the funds from one venture being up for grabs for the others? So when I asked that question, I also encourage a lot of my clients to separate their businesses. Sometimes it makes sense to do a structure where there's a parent company and subsidiaries, but a lot of times it's just as beneficial to them to just separate. And I often hear this and I cringe. Well, I have a DBA, and I have a DBA, so I'm good. I'm protected. And I just want to dispel this myth. A DBA does not create a new business entity for you. What a DBA does is gives you a fictitious name. It's just like yourself. Your name may be, like my name is Cheris, but my nickname is CJ. And more or less, a DBA does the exact same thing for your business. It gives it a nickname so that if you are conducting businesses in one aspect of your business, you're known as one name, and another aspect of your business, you're known as another. It allows you to operate under both. So I always encourage, especially where maybe the product or the service don't necessarily align, but they're complementary, to just create some separation there so that the money from one venture or the revenue from one venture isn't up for grabs with the others.
That is really good because I felt like you were talking to me just then, because that's my favorite thing to do, because it's easy just to create a DBA filing, with the Secretary of State. So Lewis on the Law is just a DBA of James Lewis Legal, and I have another DBA, and they're all intermingled. So I feel like you're just talking to me there.
Absolutely. And it's so easy. It's like, oh, these are all so related. So instead of I've already gone through the process once. Why do I need to continue to go through it each time? But, I just always pose that question. If you were to be sued, would you be okay with one aspect impacting the other, or one pool of money being up for grabs because of a wrong turn or misstep from the other side of the venture? And if your answer is no to that, then let's create some separation there. So create some separation between yourself and your business, and some separation between your business from your other businesses. That's
a good one, because it's a natural thing to first, create some separation between yourself and your business. Okay, you're like, okay, I get that part, but then creating separation between your businesses, especially if you have several different businesses, all kind of running as little mini tyrants out there.
Absolutely. And then even with that, also record keeping is a big one. I see this often. Sometimes and I can just even do the parallel to for an attorney. We receive assets, we receive money. Sometimes we're responsible for holding things in trust for clients, and making sure that you're actually doing a good job of bookkeeping and separating, or keeping track of what your assets are, what your liabilities are, and making sure that you're not spending someone else's money, or that you're not spending money that shouldn't be spent, or just sloppy bookkeeping, more or less.
Yeah.
Keep those records clean and clear. When I was in law school, I had a mentor, and she told me, sometimes you're going to have to pay for your time. And one of the things, and when she said that, I was like, pay for your time? I don't understand. So she said, sometimes you're going to wear many hats, especially as an entrepreneur. You're going to be the manager, you're going to be the marketing director, you're going to be the CEO, the COO, the CFO. And sometimes it becomes overwhelming. And one of the times when it's beneficial to pay for your time is to hire a bookkeeper, a CPA, someone who can, actually wear that hat for you, a trusted CPA or an account, or just general accountant or bookkeeper, someone who's really good at what they're doing but also trustworthy.
Yeah, I think that's pretty important. I used to do tax law initially, and so I think I don't need an accountant or a bookkeeper. I can just do this myself. This last tax year, I spent, I think, a whole entire month and a half just organizing my financial records and getting my taxes ready to file. It was brutal.
I can only imagine. And one of the fun things is, like, there are so many apps and resources available to you at this point that you don't have to,
you don't have to suffer.
You don't have to suffer. Don't do that to yourself, Just, pay for your time. And paying for your time may not actually mean that you're hiring a physical body, but maybe you're automating it in some way. MileIQ is a great example where you get to track your trips, your mileage, so that at the end of the year, you have reports already generated that you can then tell a story as to how much you commuted and how much you're due back from traveling for the year for your business.
Yeah, QuickBooks always tells me that I can track my miles and all my expenses through, and I have a QuickBooks program. Do I use it regularly? No.
Yeah. I honestly, I don't blame you. I actually decided to hire somebody for that, that reason.
And I have had this crazy client who offered me land to handle their cases. They have like 300 acres, but they have almost no money. So they're like, I'll give you a couple of acres if you handle my case. I'm just like, wait a minute. I have to wrap my mind around that. I don't know what I would do with that. It's in Twiggs County. So
wow. That's far.
Yeah, I won't talk anymore about it because it's a potential client I haven't taken yet. I'm just like, wait a minute, I have to wrap my mind around it. You're offering me acres to handle it. I don't even know how to do the bookkeeping for that.
The value in that is insane.
It's tricky though.
Yeah.
I mean, what are you going to do with that? Is it money? It's not money, So, okay, so that's the second. Are we finished with the second common pitfall?
We are, and I kind of highlighted on some of the other pieces. Like I'm giving you the broader picture and kind of blending the pitfalls in between. But another will also be, which I kind of mentioned before.
Wait a minute, is this the third?
Ooh,
no.
This is
it's
like
not the
2
third.
points.
It's 2 points. Okay, go ahead.
Which is like failing to adhere to the regulations when receiving money from investors, which I mentioned before. So SEC $10,000. Anything beyond 9999. Anything beyond that, start asking questions.
That's a great tip. I didn't know that, so that's a great tip when I start receiving when people are actually going to give me those big checks, which may or may not happen. Anyways, we're at the end of our segment. I won't give you my sad stories.
No worries.
Okay, give me some contact information for you.
Sure, I can be reached by my website, thedorseyfirm.com. That's DORSEY firm.com. Or you can reach me by phone. That number is 404-382-8832.
You're listening to Lewis on the Law. I have yet another awesome show going for you. If you have an idea for this show, if you have a topic that you'd like to hear us talk about, go ahead and contact me at jameslewislegal.com. I have a contact page on my last page. And if I don't know anything about your topic, I'll bring an attorney on who does know something about your topic, and we'll talk about it on air. Once again, this show is not meant to replace the advice of an attorney. This show is only designed to give you information to help you maybe select an attorney, decide that if you have a case at all, or if you need to hire an attorney, which is kind of the direction this show is going. This show is kind of throwing out information that might let you know if you're in a situation where you need to hire an attorney. When we get back, we're going to get to 3 through 18. I know I'm promising a lot, but it's coming. You are listening to Lewis on the Law. My name is James Lewis, and I have another powerful, impacting show going on for you because we are helping you, the small business owner. I have attorney Charis Dorsey on with me from the Dorsey Law Firm, and we are talking about the 18 common legal pitfalls that happen to business owners. I love that 18 common. You got it down to a number into science. Okay, so we're on our journey. We are now on number 3. What is the third common legal pitfall for business owners?
Contracts or the lack thereof.
Oh, that's a good one. I'm an attorney and I don't write contracts for everything.
Oh no!
I'm just like, wait, people pay me to write contracts. Why am I going to just write a contract?
Yeah,
okay.
Contracts for sure. And especially in the perspective of closely related partners. That's the common one for me to see. 2 long-term friends, husband and wife.
Oh my God!
Siblings.
You don't say I need a contract between me and my wife. She does a lot of my marketing for me.
Oh, sometimes you do.
Say it's not so.
And we see this happen often. Like things are beautiful in the beginning, and then there's always this point where you hit this turn, and it's like, do we stay together in this business, or do we part? Or do we, continue on with this matter, or do we just break the contract? And then at that point, it's, okay, well, how much do I get paid? And when we're trying to figure out how much to get paid, that's where we see a lot of conflict come up. And what ends up happening a lot of times is that they'll come to me, I'm ready to hire an attorney, I'm ready to sue my brother or whomever the case may be. And at that point, it's like, okay, well, what does the contract say? Contract? What contract? We didn't have a contract. And it's
Colette, do you hear that? You and I need a contract. I love you, but you know, I don't want you to take the 5 acres I'm getting in Twiggs County once I sign this deal. So just kidding.
But yeah, so contracts, and they come in all forms. So even from the beginning, from the inception of the business, if you're starting out with a partner, an operating agreement, or your bylaws, just telling each other how you want to be treated, and really being thoughtful about the contract formation, because what I've seen, which is just as good as not having a contract at all, is you hit the highlights, the who, what, when, where, why, and how, but you didn't talk about this unique caveat that comes up often in your industry that probably should have been accounted for in the agreement, and had you've been a little bit more thoughtful, to take in what actually happens on a day-to-day basis into account, and actually adding that in, it could have solved so many more problems. Like even from the standpoint of, I'll use a great example, events. I get quite a few clients who are in the event planning or event production arena, and with them, one of the things that I often see is like they're hiring someone to promote the event. Mm-hmm. And in that, I've seen contracts come in that don't even talk about it. They don't talk about how you want to be treated, how the branding should look, placement of the branding. Like where does your logo go? Are there certain things that you don't want your logo to be associated with? For example, I had one client who had hired a promotions event, and he, I guess, thought it was a great idea to do a one for all in promoting for the event, and put 4 different events on a background with cannabis, so the weed plant.
Oh, and, no.
Yeah, and it was completely unrelated whatsoever to their actual brand, and it was problematic.
Yeah, I can see how that would be.
Absolutely. And so,
unless you're a criminal defense attorney who specializes in marijuana convictions.
Then it's great for you, because that's a shoo-in. But yeah, so that was an issue for my client. And so having that language in the agreement says, hey, no, refer back to provision or clause and see this, and, all promotions or marketing materials must be approved prior to your release. You're actually in breach. And if you don't take this down, we will pursue other avenues to fix this. And of course, they took it down with no problem. But having a great contract in place enabled us to be able to do that. So I would say contracts, making sure that you're identifying the parties involved in the contract properly. And one thing that I see often is making sure that you're not signing on behalf of yourself, but actually signing on behalf of the business. So identifying, like when in the beginning, you want to make sure that the contract is identifying the parties properly. So it wouldn't just be Charis Dorsey. It would be the Charis Dorsey on behalf of the Dorsey firm. And when I sign, then it puts my business on the hook instead of me personally. And sometimes that's a common, and that's actually a pitfall within itself, but a common misstep that I see that allows people to be sued personally. And we don't want that to happen. So I would say contracts. And then, and with that, even with like personal guarantees, making sure that you're limiting the liability that you personally would have, especially if the initial purpose of entering into it was on behalf of your business.
Got it. So we moved through number 4 kind of well. So what is number 5?
Sure. I would say that it ties right into it, which is leaving money on the table.
Oh, you don't want to do that.
Never. You never want to leave money on the table. And so one of the common ways that I see that happen is with commercial leases.
Nice.
So
they can get you in commercial leases. There's all kinds of little things in there.
Yeah, and the tough part about commercial leases is, or commercial leasing in general, is that the forms aren't regulated. So whereas you would see with a normal residential lease, it's regulated by state law. But with the commercial lease, some of the consumer protections aren't there that you would hopefully anticipate and expect to be there. So if you don't read the lease properly and fully, thoroughly, I can throw out so many different ways that you need to read this lease, but sometimes you leave a lot of money up for grabs, even in how sometimes you'll enter into, want to have a tenant improvement, you want to structure or redo the space to fit your needs as the tenant. And sometimes, the landlord will give you this credit. But in the language of that lease, it also says that in the event that you breach, you're actually going to be responsible for paying that back, even though you never actually received physical, like actual tangible money in hand. And the credit is really just, that is really something they've already built into, because the contractors that they're using aren't, they're not outsourcing for that. And the materials, sometimes material that they already have. So, that's one way as well. Even with negotiating on the CAM fees,
Oh yeah, well
common area.
That's where they can really get you the operating expenses, CAM,
and making
all
sure
kinds of fees can be tied into that.
Absolutely, and sometimes you're not necessarily responsible for, you shouldn't be responsible for paying certain things like certain taxes or
agency fees.
Agency fees, exactly. So making sure that you're not leaving money on the table from that perspective, and then also enforcing. And this kind of ties back into the contracts piece too, but it goes both ways, which is not enforcing breached contracts. So that's another opportunity in which people leave money on the table. So someone did you wrong, you say, to hell with this, excuse me. But you leave it, you just walk away, and that contract could have been worth thousands, if not more,
Yeah, people I think are concerned about that because they're like, I got to hire an attorney, and their attorneys are expensive. I mean, the attorney's going to cost me a couple thousand. So
yeah, and I mean, you have to just weigh the reward. Sometimes it may not be of financial interest to you to sue if it's going to cost much more. But then sometimes, depending on if you have a good attorney and you have a solid case, you can recoup the money that you actually paid for the attorney as well as the original amount. So sometimes it is just worth it to go forward and pursue your rights.
That sounds like a lot of work for a lot of people. Okay, so we kind of moved through 4 and 5. Are we on 6 now?
Sure.
Okay.
And this one I love so much. I was actually just talking about this on Instagram. I love social media.
Yeah, you're an avid social media marketer.
I am. So I'll kind of tie this in, and then we can, I guess, for the next segment, talk a little bit more about it. But and right in line with not enforcing the agreements, the contracts once they're breached, I will also say not using or enforcing your non-competes, your non-disclosures, or non-circumvention agreements as well. That is something that I see. You have a great idea.
Okay, now this is all still part of 5. We haven't brought into 6 yet, right?
This is all part.
Okay, or is this
all
6?
5. No, this is 5.
Okay, yeah. So that's still the leaving money on the table.
That's still part of me leaving money on the table, but it blends or bleeds into it because, and this perspective, it also touches on intellectual property. So when you have some creative, unique idea, making sure that you are protecting it and also enforcing it. It's not uncommon to see you share an idea, and then a couple of months later, the person that you shared it with then
they ripped you off. Got it. Okay, but we'll get into that. That sounds like a lot of fun in this next segment. Why don't you give them some more contact information for you, Charis?
I can be reached at www.thedorseyfirm.com, and that's DORSEY firm.com. And then my phone number is 404-382-8832.
You're listening to Lewis on the Law, and if you need an attorney, don't listen to this show and say, okay, I can now handle my legal issue. Go ahead and contract with an attorney. You can always give Charis Dorsey a call. You can always call me if you can't find the attorney you're looking for and you need some recommendations. 404-610-0075. You can also email me at james@jameslewislegal.com. This show is now streaming nationally on every single streaming platform that you can think of, every single national streaming platform. We are even AI compatible. You can say, hey Google, because I have a Google. I don't do the Alexa though. You could say, hey Alexa, play Lewis on the Law, episode 42 with attorney Charis Dorsey, and voila, it'll start playing right out of your AI. So we are AI compatible. We're going to take over the world soon, but when we get back, we're going to go through 6 through 18 common legal pitfalls for business owners. You are listening to Lewis on the Law. My name is James Lewis, and I am your host this week and every week. And I have yet another fun, interesting, exciting, and impactful show going for you. I have attorney Charis Dorsey on with me, and we are talking, and I love this marketing concept. And our producer, Sam Davis over here, was like, he complimented you. He liked the marketing concept too. 18 common legal pitfalls for business owners. Love that. 18. And on our way through 18, we are at number 6. What's number 6 again?
Sure. It's branding and IP. So starting with a solid name. And so I'll kind of go into one of the things that I see happen. I cringe. I'm actually hosting a workshop next Tuesday on this precise thing, which is figuring out what's in a name.
And what's in a name? A rose by any other name would smell just as sweet. Is that not true? Shakespeare lying to us?
So I don't think he's lying to us. But yeah, so what's in a name? And so one of the things that I see, we come up with these unique ideas for what the name of the business should be, or unique by our standard. But when we really go through and comb through, the strength of our name from a trademark perspective, we actually discovered that it's not strong at all, or it has minimal protectability, or it's already out there. So one thing that I would encourage, or one thing that I see happen a lot, is that the business owner starts with this name and starts marketing this name, and then comes back later on and discovers that the name isn't available or that they're infringing on someone else's mark. And so many different layers to that particular issue, which could all be avoided by doing a thorough trademark search.
But isn't that expensive? I mean, is that expensive?
It depends. But I think that is one of those things where you weigh the cost. You pay the cost up front, or you pay triple, if not quadruple the amount on the back end. So I think it is absolutely 100%, 110% worth the investment. So just do the search on the front end. You want to make sure that the name that you have is available, and that that it is strong enough to go with you for years and years to come. And so I always refer people back to the spectrum. There's like a spectrum. You have on the weaker end, you have like your generic marks, and then you have generic, your suggestive, your descriptive marks. And on the stronger end, you have these arbitrary marks like Apple for a computer. Who would have ever thought to come up with that? Or, something fanciful like Xerox. What does Xerox even mean? What does Xerox mean? I think it's just no one knows. But Xerox is so strong because now this random made up word now has associated meaning with, copy services or the printing process. And so, or the actual machinery itself. And so when you think of that and how strong that is, same thing for Nike. Does anyone know what Nike means?
Yeah, he's the guy who ran the first marathon or something like that back in Greece. He's Greek god.
He's a Greek god.
Something like that, yeah.
Now, would you think to automatically just associate that brand with shoes?
Probably not. But if I thought about it, I might.
Yeah, and to imagine like you being a Greek god, and then, the original base for the word being a Greek god, and then now no one even associates the word Nike to that. Imagine how powerful and strong that brand is. You know what I mean? And when you're talking about trademarks, or talking about picking a name, you want that type of distinction. You want that type of power behind your brand. I always tell my clients all the time, there is value in your intellectual property. And there's value in your name. If you are putting yourself in a position to be able to build such a strong name on the front end, it does you a world of good, honestly. And so with that, it also means, not with that it also means, but another thing with that I see often, which kind of ties back into our last segment, was just once you create, this trademark, this name for yourself, this strong, powerful name for yourself, from a branding perspective, protecting it, creating, a strategy for protection. Sometimes that may be monitoring your mark or the name of it to make sure that no one's infringing, and then having a a plan of action for those moments in which you do find someone infringing or stepping on your toes from that perspective. So, I can go on and on about branding.
Yeah, because it seems like sometimes, especially if you build that powerful brand, I mean, what happens when it becomes like Kleenex? And I think our producer just asked me for some tissue to blow his nose, and I'm like, do you want some Kleenex?
Band-Aids.
Yep. Yeah, Band-Aids. Let's put a Band-Aid on that, you know?
And so it also is, I remember Chanel. I believe Chanel was the brand that would actually put out a statement, which would tell all of the ways in which Chanel is being used as an effort to avoid genericism.
I heard Zipper was one time a brand,
yep.
and there's actually some other name for a zipper. But
I think there was like YKK or something like that was one of the brands, or some. You see it now, like just you don't want to lose your brand, like your distinctiveness. I think even Uber was at risk or is getting close to that point, because now when you're referring to the service of having a car, like calling a car through your app, sometimes we say, we're just going to Uber there. And it's not necessarily that you're always using Uber. You could be using Lyft or, some other service. And
it seems like Lyft would be a little bit more in danger of that. It's like, can I get a Lyft?
Well, and it's amazing to see how Lyft was able to bring something so generic into something so distinctive. So
they put a Y in it?
Well, the Y in it, but now when you think of Lyft, it's like, yeah, you traditionally think of that, but now when you hear Lyft, it has developed such a strong brand within itself that now it's shifted into this strong, powerful name. So they've actually functioned or evolved from a generic term to this extremely distinct term, which is from a trademark perspective, awesome. That's something ideal that you would want to have, and that's probably something that a lot of generic brands would probably want to take a note from. How do they bring this generic phrase to come to be this distinct phrase that is directly aligned and directly associated with this service?
Excellent.
And then another piece to that too is not formally establishing ownership. And so I see this often enough with both copyright matters as well as trademark. So you have a design.
Wait a minute. Now, if you register your trademark, are you establishing ownership of it?
So it is intellectual property, just so it does establish ownership of that mark in the field across the nation as to the brand and the association with the goods or services that you're doing under that name. So it does establish some ownership rights there, yes. And then from the perspective of design components, sometimes maybe we have the great idea, but we hire somebody to create this graphic design, this graphic for us. And so not actually getting like a work made for hire agreement to establish that you paid this person exclusively for this and that they're not actually considered to be the owner is another thing where I've seen issues come up.
Okay, so that's what you mean by ownership, especially when with design and maybe copyrights.
And copyright especially. Sometimes you'll submit something and it blows up and then there wasn't no work made for hire and now that person wants credit. And this, they technically are, if they're that, they're not, but by association and by, creation, they've created this this graphic or this design or this content for you. And if you don't have, the right things in place, you're leaving money on the table, which is one of my points earlier on.
Okay, so before we run out of time, okay, I just have to do this. We're probably not going to get to all 18 here, but I want you to just go ahead and list out all 18 here.
Sure.
Okay.
Okay, no problem at all. So the first thing I would have to say would be selecting the wrong corporate entity for your business.
And that's one.
And so the second would be not fully completing the formation process.
Okay.
Then the next thing would be failure to follow business tax laws. 3. Okay. Then the next would be failing to separate yourself from your business. That's 4.
4. All right.
And then failing to separate your business from your business.
Okay. 5.
Commingling funds.
6.
Operating all of your businesses, that kind of goes into 1, but failing to adhere to regulations when receiving money from investors.
8, okay.
Okay. Failing to use the appropriate agreements where applicable.
Okay, 9.
Okay. Making yourselves personally liable for business matters.
Okay, 10.
Okay. Leaving money on the table.
11, all right.
Not negotiating in commercial leases.
Oh, okay. 12.
Not doing research on the front end with trademarks.
Okay. 13.
Okay. Not protecting or infringing on someone else's intellectual property.
Okay. 14.
Okay, yeah, that goes right.
Is that still 13?
That was 14,
was that 14?
and
Okay.
15.
Okay, 15.
Okay. And then not having terms and conditions in place for e-commerce sites.
Okay. Wow, that one's advanced. Okay,
And
we should have probably gotten to that one. We're not going to have time.
Okay,
so
yeah,
that's 16 or 17.
That's 16, I believe. And not having, and this kind of goes into that one, not having a privacy policy on the website. So you have your terms and conditions and then your privacy policy.
Okay, is that 17? Okay.
We can just count those as 16, I guess,
Okay.
together. Failing to properly plan for partnership and investor conflicts. And then failing to have a succession plan or your exit plan, that would be 18.
There you go. 18 common legal pitfalls for business owners. Give them some quick contact information for you again. We're at the end of our show.
Sure. You can reach me at thedorseyfirm.com. That's DORSEY firm.com. And my number is 404-382-8832.
You're listening to Lewis on the Law. Thank you guys for being here. I got to thank the guys that make the magic happen over there. The visionary of video, the one and only Anthony Cook over there. And the enigmatic one, our producer, the siren of sound, Sam Davis there, making the magic happen. You're listening to Lewis on the Law. I'll be back with you guys next week.